Hey everybody, how are you today on this beautiful Friday? I hope you're doing well and having a great day on purpose. We are here on the docket with Danny, and we're going to get into an update on Sean P. Diddy Combs. I'm just going to give it a few more minutes, or maybe a minute and a half or so, before I get started. If you're not already subscribed to the channel, go on ahead and consider subscribing today. Set your notifications to all so that you're notified when I go live or add new content. All right. I'm ready to get started, guys. Let's get into this update about Diddy. So, as many of you already know, Sean Puff Daddy P. Diddy Combs has been indicted by the federal government. There's currently a case open against him, the United States versus Sean Combs. As of today, well, actually yesterday, October 3rd, 2024, a new judge has been assigned. I'm not really sure why they reassigned this case. The first judge that Diddy saw was just a regular magistrate judge, like a first appearance judge. So she was not going to be on the case. But his legal team submitted an appeal to the denial of bond, and the case was heard in front of Judge Andrew Carter. Now, Judge Carter was, according to his elite attorney, or main attorney, I'm assuming he's his main attorney because Sean Diddy Combs has hired 2 additional attorneys for his case, but I'm talking about Mark Agnafilo. He indicated that Judge Carter was going to be the trial judge. But as of October 3rd, it is now Judge Aaron Subramani. On Thursday, a notice to the court docket indicated that the case was reassigned to Judge Aaron Subramani, who was first nominated by Joe Biden in 2022 and took the bench in 2023. Subramani spent most of his career as a civil litigator of complex disputes at the law firm of Sussman Godfrey. Before joining the law firm, he worked as a law clerk for Supreme Court Justice Ruth Bader Ginsburg. He's age 45, and he was born in Pennsylvania. Now, just to look over his career a little bit, it starts from 2004. It says that from 2004 to 2005, he served as a law clerk to Judge Dennis Jacobs of the United States Court of Appeals for the Second Circuit. From 2005 to 2006, he was a law clerk for Judge Gerard E. Lynch of the United States District Court for the Southern District of New York. And from 2006 to 2007, he was a law clerk for Justice Ruth Bader Ginsburg of the Supreme Court of the United States from 2007 to 2023. He was a partner at the White Shoe Law Firm of Sussman Godfrey in New York City, where he focused on commercial law and bankruptcy law. Subramani was recommended to Joe Biden by Senator Chuck Schumer. September 2nd, 2022, President Biden announced his intent to nominate him to serve as United States District Judge of the United States District Court for the Southern District of New York. So, his career in law looks like it spans a lengthy time. However, I'm still not clear on why the switch was made, but it was made. So Diddy has been incarcerated for 18 days, guys. 18 days. He's been in the clink at MDC. Far from the glitz and glamour and opulence that he's accustomed to. You know, this for Sean P. Diddy Combs has to be a difficult one. That's 432 hours, 2 weeks, and 4 days. And his counsel has actually requested the discovery in the case. However, the federal government has some seriously specific guidelines regarding discovery. And let's hop over into the discovery. Now, this was filed today to the judge. It says, "Dear Judge Subramani, enclosed for the court's consideration is a proposed protective order in the above captioned case that has been executed by both parties. The parties respectfully request that the court enter the proposed protective order. Please note that the government has redacted a limited portion of the publicly filed proposed protective order. The redacted position describes with particularly discovery material that implicates a victim's that implicates a victim's privacy interest." And they say, they quote a case for case law reference if the judge wants to understand why the finding is appropriate. But finding that the presumption of public access to a judicial document can be overcome when the court makes a finding that sealing is necessary to preserve higher values and is narrowly tailored to serve that interest. The government will provide the court with an unredacted copy directly. Defense counsel does not object to these limited redactions. And that is signed by Damian Williams, United States Attorney. Now, let's get into this protective order. Upon the application of the United States of America with the consent of the undersigned counsel and the defendant having requested discovery under Fed Rule Crim P16, the court hereby finds and orders as follows. Disclosure material. The government will make disclosure to the defendant of documents, objects, and information, including electronically stored information, as a courtesy or pursuant to Federal Rule of Criminal Procedure 16, 18 U.S.C. 3500. And the government's general obligation to produce exculpatory and impeachment material in criminal cases, all of which will be referred to herein as disclosure material. The government's disclosure material may include material that affects the privacy or confidentiality of individuals, would impede it if prematurely disclosed, the government's ongoing investigation of uncharged individuals. Now, that part of this document made my hair red. It literally made me say, like, hold on. They want to make sure that they properly redact this document so that they do not reveal other individuals that are uncharged. So that to me means that the federal government has individuals that they are either reaching out to see if they will cooperate and testify, probably even giving them agreements. Wow. Okay. Would risk prejudice pretrial publicity if publicly disseminated, may be produced with more limited redactions than would otherwise be necessary, and that is not authorized to be disclosed to the public or disclosed beyond that which is necessary for the defense of this criminal case. All right, now, sealed material. Certain of the government's disclosure material referred to herein sealed material. As sealed material contains information that identifies or could lead to the identification of witnesses who may be subject to intimidation or obstruction, and whose lives, persons, and property, as well as the lives, persons, and properties of loved ones, will be subject to risk of harm, absent the protective considerations set forth herein. Attorney's possession only, APO. Certain materials in this case raise particular risk of affecting the privacy or safety of victims or witnesses, or confidentiality of ongoing investigations. Disclosure materials produced by the government to the defense counsel that is either one, designated in whole or part as attorney's possession only by the government in emails or communications to the defense counsel, or two, that includes a Bates or other label stating attorney's possession only, or APO, shall be deemed APO material. Any material designated as APO material shall also be deemed sealed material. So a lot of their communications, guys, are going to be sealed. I would imagine in this case, as documents and discovery starts flying from the government to Diddy's lawyers, I am imagining that some of the stuff is either going to be sealed or heavily redacted. So, attorney's eyes only, AEO material. Certain materials in this case rise a more significant risk of affecting the privacy or safety of victims or witnesses, or the confidentiality of the ongoing investigation. Disclosure produced by the government to the defense that is either one, designated in whole or part as attorney's eyes only by the government in emails or communications to the defense counsel, or that includes a Bates or other label stating attorney's eyes only, or AEO, shall be deemed AEO material. Any material designated as AEO material shall be deemed sealed material. Now, therefore, good cause shown as herein ordered. So, disclosure and treatment. Disclosure material shall not be disclosed by the defendant or defense counsel, including any successor counsel, other than as set forth herein, and shall be used by the defense solely for purposes of defending against the charges in the above captioned case, including, but not limited to, preparation for trial and any sentencing appeal or collateral attack, which was commenced within a year of the exhaustion of the defendant's appellate rights. Rights involving the charges in the above captioned case. The defense shall not post or disclose material or post. The defense shall not post any disclosure information that is not publicly available on the docket in the above captioned case on any internet site or network site, including any social media sites such as Facebook. Oh, the court is not playing. If this ends up on Facebook or Twitter, to which persons other than the parties have access, and shall not disclose the disclosure material to the media. Sealed material, same thing. They cannot disclose it. Let's see. I'm not going to repeat reading those things. I'm trying to get to the next points. Defense counsel, government must either. Okay, that's the sealed documents. I'm not gonna, it's the same treatment of the documents. Like, they're holding his attorneys liable should anything leak out into the media, anything at all. Okay, this order does not protect, it says other provisions. This order does not prevent the disclosure of any disclosure material in any hearing or trial held in this action, or to any judge or magistrate judge for purposes of this action, but except to the extent provided otherwise below, shall not be disclosed or used in any form in any other civil litigation, arbitration, or other private or alternative dispute resolutions. Ooh-wee. Oh my gosh. Guys, do you understand what that means? So basically, the government is stating that any discovery that they provide to him, right? Let's say one of the victims that Tony Busby, remember Tony Busby came out with saying that he has 120 clients that he's representing. I'm waiting for the first lawsuit to be filed because he said within the next 30 days he would begin filing them. He needs to begin filing them. What are you doing, Tony? Because I honestly, with him making such a big, presence, and he's the one that alleges a 9-year-old was involved in this. I would imagine, if you're going to lead with that 9-year-old, 14-year-old, 15-year-old, and not to say that, the older people that this happened to, it's not as traumatic. It's still traumatic. It's just 9-year-old. If you're going to actually allege and assert such an allegation, I would have thought I would see like 4 cases the next day. Otherwise, I feel like he's just clout chasing. Otherwise, I feel like he's just trying to get more people to come to his firm so that he can investigate more cases and see what else he can file against Diddy. Because, put it like this. For Tony Busby, when I start seeing him filing, I'll believe it. Until then, I feel like this is just a publicity stunt. Honestly. And I know that he has a reputable firm, and I know that, he's, known in the industry and in the business, but I don't know. It just kind of, I don't know. I'll believe it when I see it. When I see it in black and white, when I see the submission of the lawsuit, then I'll say, okay, let's get it popping. And he did indicate that each suit will be filed individually. But what the state explicitly saying, they're saying that basically, if there are any victims that are suing him, he can his defense cannot take what they say in this federal case and use it against them in a lawsuit. I also want to hop back a little bit because I just saw something that kind of jumped off the page to me. And it says now that it says AEO material received by defense counsel shall be maintained. It's the same thing, by attorney's eyes only. And they prohibited that it prohibits them from sharing it with other persons, including the defendant, except for any personal personnel for who wait a minute. Oh my God, I lost my page. For whose conduct defense counsel is responsible. All visible depictions, including any photography, film, video of XXX explicit conduct or nudity, will be designated as attorney eyes only, regardless of whether it has been disseminated as such by the government at the discretion of the government. Certain AEO material depicting XXX explicit conduct or nudity may be made available for in-person, inspection only. So some of their visual evidence, they don't even want to give it to the attorney. Some of the video footage that they found in Diddy's house, they don't even want his attorneys possessing it. Let me tell you guys something. These prosecutors in New York, this is going to be their entire life. They're eating, sleeping, and pooping this case every single day. They are working on strategy. These guys are, first of all, this is a group of young people. I call them young because they're in their 40s. The judge who's been assigned as of today, he's 45. The prosecutor, if I'm not mistaken, Damian Williams, is also 45 or 46. These are young people. So Diddy's gonna need a team. He's gonna need a team. Now, they redacted a portion of this, and I cannot make any sense of it because they redacted the beginning of the statement, but it says this provision is limited to as follows: such material located on the defendant's devices or cloud accounts shall be designated as APO, attorney possession only, which the defendant may view under the following agreed upon conditions. Number 1, the material is viewed by the defendant in the presence of defense counsel. Number 2, on a device approved by the government. What? Yo, they're now playing. Why does it have? Why can't Diddy's attorney just bring the information to the prison, meet with him, show it to him on his lap? Why does the government have to approve the device? That's crazy. Number 3, in an approved private room in the jail facility or other facility approved by the government. And number 4, defense counsel ensures that such material will not be accessible or viewable by the incarcerated individuals other than the defendant, visitors, or others who are not part of the defense. Now, there's a point, it says number 3, but they redacted the first 2 lines, and it said where it picks up is materials will be made available for inspection only and not electronically produced. The defendant may view blank in the presence of defense counsel at the Daniel Patrick Moyne, I think it is, courthouse while monitored by law enforcement officials. What is that? What is redacted there? Which the defense may seek designation by the court. The government may authorize in writing disclosure of disclosure material beyond that otherwise permitted by this order without further order of this court. 11. The defense shall provide a copy of this order to prospective witnesses and retained by counsel to whom the defense intends to disclose disclosure material in advance of such disclosure. All such persons shall be subject to the terms of this order if they review such disclosure material. Defense counsel shall maintain a record of that information as to who it's been disclosed to. Wow. Okay, so there I understand them keeping the materials private and close to the fist. I mean, they are working on probably what I would consider the biggest case of my lifetime. You know, I don't think there's been a bigger case than this. And with learning that the government has indicated that they can't really disclose all of the discovery material for fear that it may basically alert or disclose other people, uncharged individuals. That's another part of this that's kind of like, whoa. Guys, I will keep you guys posted as to what is going on in the Sean P. Diddy Combs case. As soon as updates are available, I'll provide those. And man, this is mind-blowing to me. I don't know about you guys, but it's just, I feel there's a shift happening. The old guard is leaving and the new guard is coming in. But I must say that he's innocent until proven guilty. So I'm looking forward, and I'm a little uncomfortable with the government not sharing all of the discovery publicly, or redacting it to have, redacting it or over redacting it, because that's not full disclosure. But I guess they have to protect people who have decided to start cooperating with them. Look at the Young Thug trial. there's a lot of people who signed deals with the government in that trial, in that case. But with Diddy, I'm almost certain that a lot of his employees are probably going to cooperate. Victims are definitely going to cooperate, but this trial is probably going to be a long one too. I don't know that it's going to be it'll probably be longer than Young Thug's trial. What do y'all think? Let me know if you're here in the room. How long do you think this trial will be? If you're not here now and you're catching this on the replay, put it in the comments. Do you think it'll be 2 months, 6 months, a year? Let's see. Let's ask. Let me find out how long his Young Thug's trial's been going on. How long has Young Thug's... What the heck? Thug's trial been going on? Question mark. Okay, so Young Thug, the trial for Young Thug, whose real name is Jeffrey Williams, has been ongoing since January 2023. Oh my goodness. And is expected to be an 18-month trial. Wow. Woo. Oh my goodness. Diddy's trial will be like 1.5 years, 2 years in length. His trial will be like 2 years in length. Oh my goodness. Hey, Lisa says what? 2 months? You think his trial will be 2 months? OJ trial took 8 months. Yeah, but you know what? OJ was not on trial for racketeering, XXX trafficking, and transportation for the purposes of XXX. And OJ wasn't tried by the feds either. I don't think it'll be 2 months. I don't think it'll be 2 months. I mean, if it will be 2 months, that will be good. Because, guys, I do intend on going there in person to attend this trial. I plan on it. And if it's 2 months, that'll be perfect. I'm willing to stay in New York for 2 months. I'm willing to do it. But I doubt that it'll be 2 months. And also, Diddy has hired already, I think he has 3 lawyers now. Mark Agnifilo, Antonio Rico, which is kind of funny to me, but the last name, because his name is Rico, but it's IRCCO. But who else? What's her name? Alexandria Shapiro. No relation to the late great is he the late? Wait, I don't remember. Is Shapiro? Well, no relation to the Shapiro that was on OJ's case. But he's hired some really high profile attorneys, and I'm sure that they are going to mount a defense for him that's probably going to take at least, he's paying that kind of money, it's got to take them at least a good month or 2 to present their witnesses to dismiss what the government is trying to insinuate. I'm sure Diddy still has a couple of people willing to, speak up for him. Some have spoken out publicly too. So I'm certain that the defense will be able to get some people to come and testify that everybody knew what was going on and what was going down in the freak offs, and they took part in it willingly. I'm sure, because his attorney's defense is that these were all consenting adults. That's his attorney's. That's the shape of where I see his defense being brought. That this was all consensual, everything. But guys, like I said, I'm going to keep you guys updated. And if you're not already subscribed to the channel, be sure to subscribe today. I have a goal of getting to 500 subscribers before the end of the year. And I know there is no way that I can do that without you. So Bush babies, come on over to the channel, subscribe, set your notifications to all. My subs, thank you so much for subscribing. Now I'm going to put y'all on a mission. Please share my live streams. Share, share, share. Share it on your platform. Share it with your family. I just really want to get to 500 so that I can be finally monetized here on YouTube. Okay? So guys, help me out with that. I will talk to you guys later. Any additional updates that come up, I will be back. The McMartin case took 2.5 years. I was reading and talking, guys. Sorry. But until next time,